Everybody, welcome. Our topic of the webinar today is a changing landscape of the employment environment post-COVID-19. We're very thankful to have two specialists joining us today, giving their time to answer some of our questions. Just a little bit in terms of the housekeeping on our webinar today. We have a bit to get through, and there's some things that Lisa and Willie would like to bring our attention to. So what we're going to do is we're going to work through certain topics through the webinar, but we will make time at the end in order for you to pose your questions. So just be patient. In the last 10-15 minutes of the webinar, we're going to invite you to pose your questions in the chat box. So I'll prompt you as soon as we're at that point. So please keep all your questions in mind until that time. Guys, just allow me to introduce our two guests. We've got Lisa and King. Lisa is acknowledged in international publications based on peer reviews such as Best Lawyers. Lisa Ann is widely regarded as one of South Africa's leading employment and human resources lawyers. Lisa Ann was an acting judge in the Labour Court during 2019 and has chaired and been a keynote speaker at several conferences. She's regularly published in respected online and print publications, and also frequently participates in interviews where she shares her extensive knowledge with listeners. Lisa Ann has a diverse legal practice in that she also has substantial commercial law experience, enabling her to work with the boards of corporate clients to provide advice and strategic guidance in order to implement effective workplace management processes whilst maintaining productivity and decreasing labor risks. In addition to her active practice, Lisa also heads up and manages the Human Resources Department of her firm. So we're very thankful. Lisa, very welcome.
Thank you, Herman.
Guys, next up we have Willie. Willie is from K&S Labour Law and Human Resources practitioners. Willie's a seasoned labour law expert, facilitator and mediator. He has a career spanning more than 20 years in business, labour law, planning and management. Willie performed various roles as OD, HR and IR supervisor for both management and labour, including hands-on technical advice and work, training and orientation, and managing the ODI, HR, IR function. He also serves as an A-level part-time commissioner for the CCMA. His period there is since 1997 to 2004, and he was on the panels of the Councillor and Arbitrator of South African Local Government Bargaining Council, the Resolution Centre for the Motor Industry Bargaining Council as well. Myself, I'm introduced. I'm a partner with PKF in the Johannesburg area, and I'm going to facilitate today. Okay, so guys, I'm going to jump into it. The topic today is to cover the economic impact of the employment environment due to the COVID-19 pandemic, the changing norms and expectations with regards to remote working, the reduction of staff complement, flexible working hours, managing the performance of remote employees, and the POPI Act in the workplace in order to assist you to kickstart your POPI compliance journey as well. I'm going to start off with Willie. Willie, could you tell us about the economic impact on the employment environment due to the current pandemic?
I think we are all aware that the economic impact is almost incalculable. Many employers are having difficulty in keeping their doors open to survive, and particularly the small to medium price and the micro enterprises, they are having a very, very, very difficult time. In certain industries, it's more prevalent than in others, but in general, there is a huge impact on the economic situation of companies. Many will not be able to survive, and they will have to close their doors permanently. Now, employers have been exposed to the lockdown effects through phase 4 to the current one. And for the average employer, announcements and directives were sometimes confusing. And it was sometimes due to downright false information provided on social media platforms, on the internet, etc. Even the official announcements and publications were for many employers very difficult to understand, and they had difficulty in implementing those. I think that the face of labour will have changed or have changed permanently, and therefore we are using the cliche that we live in a new reality. Now, this new reality is also a fast changing reality, And we will have difficulty in negotiating the uncharted waters that we are moving in at the moment.
Okay, got it. So what are the options open to businesses at the moment to gear for this new reality, Willie?
Well, Herman, I think the first responsible advice to employers and to everybody, even to employees, is to not overreact. Any adjustment should be based on strategic realities for employers. It will be suicidal for any business to just follow a let's see what happens attitude. The short to medium term planning and contingencies for those plans are imperative. They must do proper planning. Unfortunate as it may be, the current situation forces businesses to relook their structures and consider all possible angles and options. What fits the one is not necessarily best fit for all. It remains the responsibility of all enterprises to act responsibly and with a lot of empathy. They must keep in mind that everybody dependent on them also has a livelihood. In most instances, employers are cautioned not to, or rather consider permanent decisions regarding staff and structures, and retrenchment specifically as a very last resort. They should, however, also bear in mind that when they are not going to, or not sure about whether they are going to open again or whether they are going to sustain their businesses, to make those decisions at the right time, because retrenchment is adding a lot of costs, and they may, at the end of the day, may not be able to meet their statutory obligations in that regard. They must not wait too long either. Any action in the above regard should be considered with the emphasis on the restriction of job losses and with the restoration of the national economy and for the business itself.
Yeah.
Now, these two aspects are not mutually exclusive, and most alternatives can be applied for a limited period only. Even with a close evaluation of trends and conditions of circumstances and timeframes, employers need to be very cautious on what they decide on, and that's why I said that they must take the strategic imperatives into account.
Mm-hmm.
One should not make decisions with permanent negative effects if there are temporary decisions that can be made, and I will get to those now. Now, the first option that an employer has is to retain its status of workforce, etc., as it was before the lockdown. Many employers have already done that, and they are going ahead, and they can forge on. The second option is to return to a phased work situation, and many employers have already exercised that option as well. That is to let their employees return to their normal positions as and when they are required to do so. In this instance, it is, however, important to ensure that the criteria on which the people are re-engaged are based on equitable and fair and well-communicated principles. The third option is to retain the status as before the lockdown, but to let the employees come into the workplace for shorter hours or on a rotational basis or whatever the case may be, with commensurate cuts in their income. Again, employers need to consider carefully how they are going to affect this and what criteria they are going to use. These criteria will have to stand the test of equitability, fairness, and legibility. Then there is the temporary staff layoff. That is where an employer have to close a part of its business or keep its whole business closed. There are many restaurants and people in the catering industry that could not open until now. And after the TERS situation has come to, or ground to an end, and they can no longer claim for TERS, people have to rely on UIF. But there are employers who cannot open at the moment. Then we get to the very difficult one, and that is the retrenchment of staff. And the retrenchment of staff can be for a part of the business, for a section of the business, or it can be for the whole of the business or everybody. I dealt with somebody yesterday that had to close its whole business. This will also include where an employer feels that it is imperative now for him to outsource some of its functions because it is cheaper to do so, or because he has to concentrate on the core business. That is also included in this one. Now, retrenchment of staff is done in terms of Section 189 of the Labour Relations Act. 189 is for people or for employers with employees with less employees than 50, and 189A for employers with more employees than employees than 50. So the Labour Law, the Labour Relations Act, requires certain steps to be followed there. The national lockdown and the regulations in terms of the national lockdown did not affect the LRA or the BCA. So those two laws, especially those two laws, there are other labour laws as well, but especially those two laws are still the laws that regulate labour relations, and they have precedence over all other regulations and laws as far as labour is concerned.
But if I can just pause there for a moment, especially now that you went into the legalities behind choices to restructure my business as a business owner or a business executive, this seems relatively complex. So it doesn't seem to me like this is something that the average business would take on their own. It sounds to me like you would need a specialist in order to go through any of these processes. Am I correct, or is it a relatively easy and straightforward process?
It is definitely not a straightforward process. We would really advise that employers, where they are uncertain or where they don't have a specialist human resources department or an IR department, that they make use of legal advice in this regard. There are many pitfalls, and there are many things that they need to take into account. So it is very important that they make sure that they do the right thing. Also, they must please bear in mind that they are working with the livelihood of people, so they should not take this decision easily, and they should take it with circumspectly. But the individual purposes or the individual circumstances of an employer will demand where he is going and what he has to do. So we really urge employers to be careful on what they do and how they go about this.
Thanks for that, Lisa. If I may put you on the spot a bit, how would the employer then practically go about reducing salaries if that is one of the options that the employer would choose to exercise?
So Herman, what we've encountered in our practice over the last few months, and specifically when lockdown was happening, is there was a great need of employers to reduce salaries of employees because of the fact that they obviously didn't have the cash flow and the income that they would normally have had during the last few months. So our advice was always that it is important to consult with the employees that may be affected, so as obviously to try and get their buy-in and consensus. Now, obviously, if a workplace is unionized, then the advice would be that the employer should meet with the union officials and shop stewards for the purposes of obviously discussing the reduction in remuneration. In my experience, what has often happened is that employers that have quite a number of staff, and given the fact that a lot of people are currently working from home, it's not always easy to obviously get everybody together in a group meeting to have these discussions. So what a lot of my clients have done is, with our assistance, have addressed comprehensive letters to the staff in which they've obviously set out the rationale behind the reduction in remuneration, what steps the employer has taken prior to proposing the reduction in remuneration. So really it should be one of the last steps. And of course, the period of time that the reduction may be in place. And what we've done in that correspondence is really to say that to the extent that anybody has any comments or objections or wishes to raise any concerns, that they have to do so by a certain deadline. And that obviously opens up the level of engagement between the staff and the employer, who are obviously working remotely. And in my experience over the last few months, a lot of my clients have done this, and there have only really been a few employees that have really put their hands up and said, well, you know, our financial situations are such that we can't afford this. And in those instances, we've been fortunate to get the UIF TERS assistance to try and obviously assist the employees with that little bit of a gap that's been done in their salaries. And of course, there's also a lot of employers have opted for pension fund or provident fund contribution holidays, which has assisted in that the employees haven't had to contribute towards their provident funds. Obviously, long term, it hasn't been ideal, but in the short term, it's actually put a little bit more cash in the people's pockets. So my advice is that you need to obviously have discussions with your staff and make it very clear the reasons why. When you don't communicate with your staff, that's when problems arise, because that's when people become very bitter and they become disgruntled, and it creates a loss of trust in that relationship. So as long as you're transparent and you are honest with your employees, then I think you are going to get buy-in, because I think the majority of South Africans have seen that there's huge amounts of retrenchments happening in the country and throughout the world, and really those that are still have jobs at this point in time are, in my experience, quite grateful to have jobs. Obviously, if an employer doesn't try and get the buy-in of the employees and get consensus and communicate, and merely unilaterally implements the change, then of course that risk of the employee going to or a group of employees for that matter, going to the CCMA and declaring a dispute, saying that there's been a unilateral change to their terms and conditions of employment. And what that really means is that when it gets to conciliation at the CCMA, the CCMA commissioner may issue a certificate of outcome which allows the employees to go on strike. And the employees can give 48 hours notice thereafter and go on a strike. Now, in my experience in these difficult times, it doesn't really help an employee, because as we all know, to embark upon a strike, it's a no work, no pay scenario. So as I've said to you, in my experience, I haven't actually seen employees referring these type of disputes insofar as the employer has attempted to get employee buy-in. So really just communication is key at this point in time.
Okay, got it, thanks. So there's two components. If I choose the option of reducing salaries, I do have the legal component, so I do need a legal expert to help me on that side, but the human component you're emphasizing as well, to make sure that there's open and clear two-way communication around it. I believe the next option would possibly be to implement short time, or hopefully as a last resort, layoffs. How would the employer go about implementing short time and layoffs?
Herman, the short answer is with a lot of caution and with a lot of empathy. And it should be, as Lisa has just said, with through a well-communicated process. The employee should be informed, and they have the right to know what is happening with the business. And they should know where the business stands at any particular moment. Now, it needs to take place, and again, I want to emphasize what Lisa has said, that there must be a consultation process, and in that communication process, they must be informed that these two steps, a short time and a layoff, is short of retrenching people, which is a permanent step. Employers are best advised in any event to take legal advice on this and to make sure that they are on the right, that they do it in the right way, not only for themselves, but also for their employees. I want to re-emphasize, we must always remember that the employees are dependent on their livelihood from the employer in most instances. So we need to treat them with empathy, and we need to treat them with the necessary understanding of their circumstances.
Billy, just a quick practical question. If I just simply completely run out of cash, are there any options available?
Yes, there is. The UIF, the Unemployment Insurance Fund, made provision for short time or for reduced hours. It is code 17 on the new UIF UI 19 form, and they can apply for employment assistance from the UIF. However, it is not an easy process, and it is also a long process. As we have experienced with the TERS applications, it may take time before people are getting the benefits that they apply for. But they need to be patient, and if an employer cannot pay, he cannot pay. The first responsibility of an employer is to keep his business open, because by keeping his business open, he retains jobs, and he reduces job losses over the country, and that is very important.
Okay, thank you. I want to move on to the impact of a lockdown, specifically in the workplace, relations within the workplace. Willie, if we could stay with you for a moment, do you mind just expanding a bit on dispersion of the workforce?
Yes, through section phase 5 and phase 4 of the lockdown situation, many employers could not bring their employees back to work. But employees were able to perform their work from home, and the employer enabled them to do so by providing equipment, providing connectivity, providing the channels to which on which reporting could take place, etc. Now, to bring those people now back into the workplace poses a lot of challenges. There are those who have found it very difficult to work out of a team. And for them to be now on short term or even on a layoff aggravates the whole situation, and it leads to a lot of trauma. There are, however, others who really like this whole situation, and they wanted to carry, or they still want to carry on in this regard, because they are much more productive and they are closer to their families and so on. There are, however, business imperatives that forces them to come back to work. If you have a project team approach or a manufacturing type of thing, you cannot do it from home. Now, for those who find it difficult to come back to the workplace, or find it difficult to work from home, forced to work from home, the trauma had an effect on their behavior. And we find it on a regular basis in the workplaces, and it manifests in very quite a number of behavioral aspects that we have to deal with now. Now, under normal circumstances, the employer will just tick it off against his list of disciplinary offences on his disciplinary code or procedure, and he will carry on then with discipline. Now, we urge the employers to be very careful on how to deal with this, and that they do this with empathy, and bearing in mind that these things do have an effect on the people that are working with them. Now, the type of behavior that we find emanating from the lockdown is, first of all, aggressiveness, and that leads to insubordination. It leads to absenteeism. It leads to poor performance. People cannot cope with the reality of getting back to work and working to order again. Now, the reason for that is there's a lot of anxiety. They are still concerned about the fact that they may pick up the COVID virus and become ill, and they spread that virus to their families. Now, unfortunately, there are also those employees who want to use this opportunity to get as much time off as possible, and to get the employer to pay for it, or for the state to pay for it. And they devise all types of things to just not to get back to work, or not to work again. Now, all these things provide or result in tensions in the workplace. Now, as pointed out, abnormal behavior in the workplace will in all likelihood be addressed through the disciplinary process of the employer. Discipline in the workplace in the aftermath of the lockdown should be considered holistically. Employers need to take the influence and effects of the lockdown and the pandemic into account. At the same time, employers have the right and even the obligation to apply discipline, because the wayward employee should not rule the roost. It should not make it difficult for all the others who are really earnest to make the thing work to be unable to do so. Now,
just something on my mind. There's something practical that's come up with us. If there is, for instance, a staff member who does test positive for COVID, does another staff member have the right to refuse to come to an office if an employer requires them to do so?
Sorry, Arvin, I missed that one.
If an employee, for instance, if an organization has an employee or employees who have tested positive for COVID, does a different employee in that organization have the right to refuse to go to the office of that employer?
Harmony depends on a number of things. If the employee, the other employee, let's say number 2 employee, if that employee has been in close proximity, the likelihood that he may have been infected is there. So it would be best advised to report to the employer, and the employer will need to take or base his actions on the evidence available to him. Now, there are regulations, or in the regulations there are prescriptions on how to deal with this, and I would urge employers to stick to those. Please do not make decisions based on your intuition or on your instinct or whatever. Follow the regulations and make sure that you stay correctly, because you are playing with the lives of people and their families, because they can be infected. And the best thing would be to involve the Department of Health to make a screening. If the employee has not been in contact with the person and he chooses to stay at home, and there is no real reason for him to stay at home, then it becomes no work, no pay. Again, one should be very cautious about this, because there are so many contingencies that one has to take into account that it is not an easy decision, and it's not a one fits all type of scenario. One has to be very careful in making that decision. I would not like to go too much further on this issue, because
so there's no simple answer. It sounds like, again, you do need to speak to a labour expert when something contentious comes up.
I would definitely advise the employer to do so.
Got it. Thanks.
Now, when an employer has people working from home, it is imperative that that employer has a very well known and a very well publicized policy and procedure for the people working from home, so that the employer can follow their work performance, etc., and to hold them accountable for what they should be accountable for. Now, employers must ensure that employees working from home on a more permanent basis are logged into the command system, and that the necessary means and protocols exist to facilitate optimum exchange of information. Exchange of information and communication is a very key aspect to this whole thing. Unfortunately, there were a lot of rumors, miscommunication, and false news that were distributed during the early phases of the lockdown, and still is on the social networks, etc., and on email. Now, employers are well advised to make sure that they have a very good information policy or electronic information policy or computer policy in place to ensure that their employees adhere to those. Since more staff would be increasingly reliant on these platforms, it must ensure that its policy is of such a nature that they can do so without being infringed in terms of the POPI Act, which we will address a bit later on. Now, distributing and sharing of rumors, unwanted and false information should be strictly dealt with through the disciplinary process, and it should be dealt with very decisively by the employer, because it is a problem in our working environments.
Okay, got it. Thanks. Just on that point, Lisa, if I can just bring you in, following from what Willie just mentioned with regards to, for instance, working from home, what contractual obligations would your employer and employee have to fulfill in terms of working from home during lockdown, or potentially after lockdown, if I could add that?
Yes, so obviously we've seen quite a shift in the workplace in terms of people working from home, and I think what we are going to see is there's a lot of clients have indicated that they're looking at smaller premises, etc. So we are going to see a change in the work environment, that more and more people are probably going to work from home more permanently. And what we've said is that it's very important, as Willie has just said, to have a proper work from home policy. And the employer needs to really apply its mind in drafting this policy to ensure, number one, that it's very clear to the staff what the boundaries are, and of course, most importantly, to deal with the protection of personal information, which we'll get to a bit later. What I've said, and what I've said to a lot of employees that have approached me, is that to work from home is not a right. You've got no right to work from home and demand that you can work from home. It's a privilege. So it's very important for employees to understand that they remain bound by the same terms and conditions as they ordinarily would have been bound by if they were in the office. So if your working hours, for instance, are from 8 to 5, you're expected to be at home and working during those hours from 8 to 5. If you then decide to pick your kids up from school and take them to a doctor, etc., you may very well make yourself vulnerable to disciplinary action, unless, of course, you've got the prior authorization of the employer to do so. So it's very important that the employer sets out in a very well-documented policy what the rules and regulations are, and of course how their performance will be monitored. I understand that there's a lot of applications that have come into existence in the marketplace that people can have installed on their computers so as to determine how many hours and minutes or whatever the person has been on the system, whether they obviously, for instance, surfing the internet during the time that they should be working, what type of sites that they are in fact surfing. And what's very important in that regard, and I think I'm going to go into the next question if you don't mind Herman, is that it's important for employees to understand that any form of misconduct which would ordinarily take place in the workplace is applicable from working from home. So if I'm sitting at home and I'm on the internet surfing pornography, I most certainly can be disciplined by my employer. But at the same time, employers have to be cautioned as to whether they can in fact be monitoring all this activity whilst the employee is at home. And that's where it's very important that the work from home policy and their information technology policies are very clear in terms of the protection of their personal information, and that the relevant consents are obtained from the employees that allow you to search what they're doing on the internet, what they're doing in their emails, that you have that access to that information. So my advice to all companies that have allowed people to work from home is to have a proper policy in place and to ensure that that policy contains the relevant data protection clauses and the consent. So the employees must specifically say, we consent to our emails being monitored by our employer. We accept that if we send personal emails from our employer's email, that will be seen by our employer if they go into the system. So those things are very important, because if you don't have that consent and you find something untoward on an employee's computer or activity that they've been getting up to on the computer, it's going to be inadmissible to actually use that information because you would have breached their privacy. So it's very important, as I said, that those documents are drafted properly, and I think going forward more and more employers are going to need these documents to be drafted.
Okay, so flowing from that, what are the privacy rights that the employee is entitled to?
So Herman, as we all know, the right to privacy is constitutionally entrenched in the South African Bill of Rights, and that's always been the case. Recently as the 1st of July 2020, the Protection of Personal Information Act, the POPI Act as we all know it, came into effect. And employers are cautioned that they've got a period of 12 months from the 1st of July to ensure that they put everything in place, because as at the 31st of June next year, there's going to be serious penalties for an employer that doesn't comply. So employees' rights are protected in terms of the POPI Act, and all the relevant consents must now start being included in your contracts of employment, your policies and procedures, and hence why I say when they're drafting these work from home policies, it's important to ensure that all the consents in terms of POPI are included into that particular policy and contracts of employment.
Understood. So if we can just focus on the Protection of Personal Income Act for a moment, Lisa. Can I just start by asking a broad question of what does the POPI Act apply to?
Yes, so the POPI Act applies to the processing of personal information, which is entered in a record by a responsible party by making use of automated or non-automated means, where the responsible party is either domiciled in South Africa or, for instance, is not domiciled in South Africa but makes use of personal information contained in South Africa. So for that, for instance, a company that's a foreign company that's using a website that sells online goods and you sell into a South African market. We all know that when you go onto these sites and you purchase something, you have to put in your name, your address, a lot of personal information. And those companies that are selling to the South African market will be also required to comply with this POPI Act. And of course, then it's important to understand that personal information forms a bulk of HR processes in businesses. So it most certainly applies to employees as well.
Okay, so responsible party, what would that be?
So a responsible party would be the employer, for instance. It would be any public or private body or any individual, for that matter, that has to determine the purpose of the personal information and how that personal information is processed. So in an employment environment, I would say it would be your HR department, most certainly, that has control over that information within your business, and obviously has to decide how that personal information is used. So all employers out there are regarded as responsible parties and will have to comply with this act.
Okay, so how would the act apply specifically to the employer and the employee?
So the act places obligations on the employer to protect the personal information of employees, and in doing so, the employer has to take steps to prevent the loss of, the damage to, or unauthorized destruction of personal information. We've seen, I think Garmin recently was hacked, and all that personal information of a lot of obviously subscribers was distributed and hacked. And it's important that an employer have processes in place that protect all the employees' personal information. And when you think about it from an HR perspective, the amount of personal information that an employer has in their possession in relation to the employees is enormous. It would be information gathered during recruitment processes. It would be information during training procedures, promotions, discipline, biometrics, the monitoring of performance, customer services, health and safety in the workplace. And it really revolves around, we must understand that often we've got information about people's marital statuses, maybe even their religion, their sexual orientation, their medical history. So there's a lot of personal information that an employer has that it needs to ensure that it is kept private, and they need to put those security measures in place.
Okay. Who are then the data subjects within an employment context?
So in an employment context, it will be anybody to whom personal information relates. So in employment context, it would be your previous job applicants, your job applicants currently. So it's important, for instance, that if you have people that apply for jobs online, candidates, that go through a process online, that they put in all their personal details, that you ensure that the relevant consents to use that personal information are included in your process on that online application, that there may be a block that has to be ticked, for instance, that says that they consent to the information being used in terms of the POPI Act. So all those online processes and recruitment processes are most certainly going to have to be looked at in fine detail to ensure that they comply. It would apply to previous employees, what you do with the information of previous employees, current employees, people that have been seconded to your employment, even a lot of companies that make use of labor brokers that supply temporary labor. All the information of all those people that come into your business in one way or another, contractors, that all that information of them personally falls under the realm of this act.
Okay, got it. Willie, I'm just going to pause a little bit at the moment with regards to zooming in definitions in the act as well. And Lisa, if you don't mind, I'm just going to jump to compliance in terms of the POPI Act. So as an employer, and it sounds to me like the POPI Act is going to directly flow into managing my employees and my rights to make agreements in terms of employment with my employees. So the question is, what would I as an employer have to do to be compliant to the Act?
So as I said, it's very important to understand that the clock is ticking as we're sitting here at the moment. And we currently, as I said, the 1st of July was when you had 12 months to comply. We've now just passed the 1st of September, so we've got 10 months to comply. And there's a lot of work that employers are going to need to do. So my advice is to start doing what has to happen before you start scrambling around in June next year, trying to get things right. So the first thing they need to do is appoint an information officer. And an information officer is the person that will be formally appointed and legally appointed and will be the custodian of the process and the information, the personal information within that business. If you don't formally appoint an information officer, by default, the managing director or the CEO of the business will be that information officer. So it's important that when you appoint this person, that it's a person that's responsible, that is trustworthy, and will take the job seriously, because if it's not, you could have serious implications for the employer. The next thing that the employer should do at this point in time is to conduct an analysis of all the personal information they've got, and to look at, firstly, the following conditions is what's required in terms of the Act. So you need to look at the purpose for which that information was collected, okay? You need to look at the quality of the information. So if you've got information that is absolutely obsolete of employees that were in your employ 20 years ago, you could probably start destroying that, because to get consents is going to be almost impossible at this point in time. You need to look at why records need to be retained and for how long. So as I said, if a person's been with you 20 years ago, rather destroy that information than keep it, because it may become problematic going forward. Then the most important thing is you need to look at your security measures. You need to look at what security you've got in your systems, whether people are able to hack the systems, because personal information is valuable information and people sell personal information. So it's important that you look at that seriously to protect that information, and not only in terms of soft copy that's sitting on your clouds and in your servers, but actually who is responsible for those personnel files, for instance. In our offices, we've got personnel files that are hard copies, and it retains all the information about people's warnings and medical health and sick notes and whatever the case may be. And whoever is in charge of that needs to make sure that that stuff is locked up, that only one person really has access to that information. You don't want lots of people having access to it, because it becomes very problematic as to account for, if anything happens with that information. And then, of course, you need to ensure that you have the relevant consents to the use of that personal information. So my advice has been, employers have said, should we start redrafting our contracts of employment? And that could be a nightmare. So my advice would be to potentially just have a addendum, so like a one-pager addendum to your current contracts of employment, where you actually specifically deal with the protection of personal information. And it contains the relevant clauses in terms of which the employee consents to the use of that personal information for the purposes of which the employer needs to manage the business, etc. And that would be sufficient in my view. So no need to go and redraft things, but obviously going forward, any new employees, you'd have it encompassed in the contract of employment. So that would be my advice going forward. Also, what employers need to do is they need to look at their policies and procedures, their IT policies and procedures, their contracts with suppliers, with customers, that it all contains these data protection clauses. So best to obviously go to an attorney who's obviously well versed in the POPI Act to obviously assist with the drafting of all these relevant clauses. It'll be a once-off expense, but it'll be well worth it going forward. Also, they need to have a POPI policy in place, and they need to provide training to the employees, that employees themselves understand what their rights are in terms of POPI and what they are consenting to. So that's very important. Also, employees have the right to have access to their personal information. And I know that a lot of companies out there have employee self-service systems in place, where people can obviously log onto a system and check all their details. And that's probably the easiest thing to have. And maybe in that process, consents can even be built into those programs. So as I said to you, there's a lot of work to be done, and it's important that employers start doing it rather sooner than later.
Okay, got it. Thanks for that, Lisa. Kelly, I think we're just running into a little bit restriction on time. So I think what we should do is maybe to move into the questions. Willie, Lisa, you guys are welcome. Just if there's something else you want to bring up that you think is very important in terms of compliance to POPI, then please feel free to do so. I'm just going to move to the comments on the right, and if you don't mind just helping me to filter through these, Kelly. I see quite a few in terms of requests for recordings. Yes, there will be a follow-up. There will be a follow-up communication. So Kelly will send contact details if you have specific questions to Lisa and to Willie, then you can pose those. I'm going to move, Kelly, just interrupt me if something comes up because I won't have both screens open on my side. I'm just going to move into some of the other practical issues which came up. This kind of came up earlier and Willie answered the question, but I'm just going to ask it to you as well, Lisa. Can an employer place a worker who presents symptoms of COVID-19 on sick leave?
Yes, most certainly, Willie. In fact, I think there's an obligation that the employer must place that employee on sick leave. There's been a lot of questions posed to us over the last few months. What if a person doesn't have enough sick leave? Maybe they've exhausted their sick leave entitlement. And in that case, there is a provision in the UIF that you can actually apply for an illness benefit. So, the person must most certainly be at home. And if they've run out of sick leave, it's unpaid from the employer's perspective, but they can apply for UIF and the employer should help them in applying for UIF.
Got it. Thanks. Thanks. Clifford, I've got a question here. Can the company insist during level 2 to insist that all staff come back to work at the office?
They're referring to level 2.
Level 2. Can the company insist during level 2 that basically at the current level that we're at, the question is, as an employer, can I insist that everybody must come back to the office?
So in my view, I would say that if you are able to comply as an employer with the regulations in terms of social distancing, that 1.5 meters apart, if you're able to provide them with masks, with the sanitation, etc., and you are able to ensure a safe working environment in compliance with those regulations, I do believe you could start saying that people need to be coming back. If you are unable to do that, then of course you're going to have difficulty because you will be breaching those regulations. So it's important for employers to understand the regulations so that they can ensure compliance, because that's important from an occupational health and safety perspective.
Okay, got it. Thank you, Adele. Is it advisable to go through the poor performance hearing process during lockdown? Are employers not meant to be more lenient during this period? Willie, can I drop that brick into your lap?
Yes, again, Herman, as I said earlier on, the employer should deal with this in a compassionate manner. Poor performance, however, has a direct impact on the productivity and the effectiveness of the company, efficiency of the company. If the poor performance becomes of such nature that the company cannot produce what it should produce, or that the employee cannot produce what it should produce, it should be addressed. Now, poor performance is a specific aspect of employee-employer relationships that need to be addressed in terms of Schedule 8 of the Labour Relations Act, and the employer must go through all the necessary steps to ensure that everything has been done that could be done to ensure that the employee performs well. If the employee then continues not performing well, then eventually the employee can be, the services of the employee can be terminated based on a fair process and for the right reasons, a fair procedure.
Okay, does that mean that I should be lenient because of what's happening with lockdown, or in your view, should I be holding everything to the same standard throughout?
I think the standard of performance should not be negotiable. But having said that, we should have empathy. We should allow for people to adjust to the new working environment. Even if they come back to the old working environment, it is a new situation for them. I think we should allow for that, and we need to be compassionate about it. We need to have a lot of empathy with the trauma that the whole situation has brought about in the minds and in the abilities and the behavior of the employees. But at the same time, if you have to perform, to produce the services or the product that the company has to provide, and it needs to be addressed. Discipline did not fall out of the equation because of the pandemic. It is still very much part of the company's right to apply discipline as and how it should do so. It is an obligation on the employer.
Okay, thank you. Thank you, Peter. What is employers' responsibility to provide ergonomic seating, etc. at home when they work from home? If I can maybe expand that question, Lisa, as well, just to say in general, what is my responsibility as employer in terms of providing a home office for my employee? Am I obliged to, for instance, get hardware for them to perform their work at home?
So what's important, once again, is to obviously assess your own operational requirements in your physical offices. So insofar as you can comply with the regulations and employees are able to come back to work, I don't believe that you've then got an obligation to set up an employee in a home office. If, of course, you as the employer are unable to provide that safe working environment in your own offices and you are requiring employees to work from home, you may then be required to provide them with data, to provide them with laptops or whatever it is to perform their duties. But insofar as the office is open and available to the employees, I don't think they can demand to work from home and insist on you providing all the information, all the technology to them.
Okay, thank you, Warren. Can a reduced salary option for employees drop below the sector's minimum wage if agreed by the employees and the union as well? Who'd like to take that one?
The minimum wage is the minimum wage. You can have people working for reduced hours, but you cannot pay less than the minimum wage. The minimum wage is regulated through the National Minimum Wage Act. That act at the moment for normal workers is, or the amount is R20.76 or 76 cents per hour. And if the employee works lesser hours, they must at least receive the hourly rate of that amount for the hours that they work. If an employee has been remunerated on a much higher rate, I would suggest that if there is a reduction in that, it should be negotiated. And it should be negotiated very carefully and it should be recorded in the process. And it should be for a period only. And that period should be stipulated. It must be a regulated situation. It cannot be an unfazed or a thumb suck situation. It must be regulated.
Understood. Thank you. Thank you, Leonard. Do we need to obtain, Lisa, if I can bring this one to you, do you need to obtain POPI consent from past employees where you hold personal information during the retention period?
So what's important is that, as I said to you, is that in doing the analysis over the next 10 months before you actually obviously could face fines, etc., is you need to really determine what information you need to keep. So if the past information of an employee is no longer relevant or necessary in your business, I would rather ensure that you destroy it. If it is important to keep, then you would need to contact that person to get the relevant consent. So they are data subjects in terms of the Act, and you would need that consent. So any information that you're going to keep in your business post the 30th of June 2021, you're going to need the consent of those people that information you have.
Okay, thanks, Lisa. Thank you, Charles. Charles has asked around COVID being a driver for renegotiating. He specifically talks about commissions, but if I may just expand that to just salaries in general, is it a valid legal basis in order to renegotiate a level of income with my employee? Yeah, it's fine. Go ahead, Lisa.
Okay, so what I would say is, obviously COVID has affected businesses operationally and economically. We understand that, okay? So if it has in fact impacted your business from an economical perspective and a financial perspective, then you may be able to renegotiate terms and conditions as an alternative to retrenchments, okay? So you say to people, we may have to embark upon a retrenchment process, but instead of doing that, we'd rather have everybody or this particular area of the business reduce their income or change their commission structures or whatever the case may be. But bear this in mind, is that it's broached as an alternative to retrenchments. And if you're going to say it's a financial reason, then it's legitimate. and the employees could actually ask for access to that financial information to satisfy themselves that it is financial. So my advice to employers out there would be to be cautious and to only use COVID as a reason if in fact it has impacted your business economically. Don't use it merely as an opportunity to, change salaries and to make your business more profitable, or to, that is going to be problematic. As long as it is genuine and an attempt to save jobs in a business, you could potentially do that.
Got it. Thanks for that, Lisa. Thanks, Paul. If an employer is now on a 4-day work week, does the annual leave accumulate at the same rate as when the employer had a 5-day work week?
Herman, it is a bit of a difficult question. In the first instance, the basic conditions of employment did not change. The basic conditions of employment make provision for a certain amount of leave that is applicable to people, and that condition is normally written into the contract of employment. Now, the contract of employment can make provision for the annual leave, or it can make provision for the accumulation of leave for 1 day for every 17 days work. Now, if the contract of employment did not make provision for the 1 day for every 17 days work, it will have to be renegotiated. I think, and that is a logical conclusion for maybe employers and employees, that if you work on a 4-day week instead of a 5-day week that you used in the past, it is a basis for negotiation on how to go forward. Individual circumstances will again apply and will again determine how you go about this. And I think, again, it would be best advised for the employer to speak to his labor advisor, legal advisor, or whoever it is, to make sure that they go about it the right way. But the conditions of the Basic Conditions of Employment Act did not alter due to the regulations that led to the lockdown.
Okay, thanks for that, guys. We're squeezing a lot over time. Apologies, Kelly. I'm going to work one last question in, and then I'm just going to wrap up. Thank you, Haley. Haley's asking, when retrenching, are employees required, or employers required to work on the last in, first out scenario? Does that need to be a consideration for the employer?
So what's important to understand is that it is the most sort of acceptable and objective selection criteria. So last in, first out is normally what unions are more likely to accept as being fair and reasonable. But of course, we all understand that sometimes you've got an exceptional person with brilliant skills and experience that you may need to retain for operational reasons. So what's also become apparent over time is that you can have a selection criteria that is the retention of skills with a consideration of LIFO. So LIFO is normally, if you've got 2 people of a very similar skill set experience, then you would use LIFO. But if you can validate as an employer that you need, for instance, a person with a BCom in that position, that would be a reason to retain the person with a BCom as opposed to the person without the BCom, for instance.
Okay, thanks for that, Lisa. Guys, unfortunately, we're out of time. So humble apologies for not getting to all the questions. As I've mentioned, what will happen after this is Kelly will make information available about the webinar. Kelly, my understanding is that there will be video clips as well as shorter inserts on the relevant topics from this afterwards. But then specifically, if anybody has questions, you will be able to check in with Lisa and with Willie directly. And I also invite you to engage with your local PKF office. All throughout South Africa, PKF has specialists in all the various offices. But please look out, if you were on this webinar and you've registered for this webinar, you will receive that communication from Kelly. So just to the team, Kelly, thank you so much for putting this together. Lisa, thank you so much for the insights. Willie, I certainly learned a lot. And most importantly, thank you so much for everybody who attended. And let's open the communication, and best of luck with running your businesses successfully through these difficult times. Thanks.
Thank you. Thanks for the opportunity.
Thanks, everybody. And I thank you, Lisa. It was a good opportunity to share this with you.
Thank you.